Thank you, Simon, and thank you to Christy as well and the Nova Scotia Woodlot Owners and Operators Association. It's always nice for a chance to get up to Cape Breton. Coming across that little green bridge always brings joy to my heart. So I'm going to chat with you. I have a background in law and in forestry and biology, and I also have some books for sale in case anyone wants a book. There's some books out in the lobby there. They say that the only things certain in life are death and taxes, and death and taxes play a large role in woodlot management. Probably most of you know this, but there are definitely interesting options to treat your woodlot as a business. If you are actually planning on selling products from your woodlot, whether that's timber or whether that's non-timber forest products or what have you, if you want to be generating some income from that property, it's highly worthwhile to think about running it as a business and then taking advantage of whatever tax advantages there are, and there are tax advantages out there to take advantage of. I run a small business myself, and I'm always looking for ways to take advantage of where I can avoid tax where possible. And certainly, if you are operating a woodlot and can treat it as a business, you could have some benefits that way. There's also, by managing your woodlot as a woodlot, managing your property as a woodlot, especially if you have a woodlot management plan for your property, then when it comes time to pass that, if you decide to pass it on to family rather than, or selling it, you can potentially reduce your capital gains tax burden by having having a woodlot management plan for your property. So something to think about for sure.
There's a slide advancer there too, if that's easier.
There are some of the issues with land ownership. Sometimes landowners are surprised to learn that we don't own the land underneath the trees. We own just the vegetation and up. Down from there, it's technically the government that has the rights to minerals under the trees, under the vegetation. If you run into a situation like that, unfortunately, it's rare that this would happen. But those that want to explore or even conduct a mineral extraction from a property, if they happen to find minerals on your property that they want to explore or extract, they do need to seek permission from the landowner, and there has to be compensation involved. But unfortunately, if push comes to shove, the Minister of Natural Resources can actually override a landowner's objection to mineral exploration or extraction. So that can get into a bit of a tricky situation there. But at any rate, you can negotiate compensation for that, for the disturbance of that land. If you decide that you don't want to do any timber extraction from your land and you want to see your land protected in the long term, like through generations, and you're looking at establishing some sort of conservation measures for your property or even a portion of your property, then there are ways under legislation to have it designated as an ecological preserve or as a wilderness area, and then that actually does prevent any new mineral claims from being established on that property. So that's one way, but it does mean it's a pretty extreme way because it means you're giving up the rights to harvest timber from that land. But if you're not planning on that anyway, then that can be one option to consider. I'm just kind of touching on topics here. I know we have a pretty limited time here, so I'm just kind of touching on topics. But if anyone wants to get in touch with me down the road, don't hesitate to do so. Happy to chat about all things woodlots. Timber theft. Timber theft is it's an awful thing. It's with the boundaries the way they are. It's oftentimes there's just very little evidence on the ground of where boundaries actually fall. And it can be really tricky when a contractor or a neighbor is cutting timber and it's like, oops, I didn't realize the boundary line was there. It's really tricky to prove that that was intentional theft. And so that's why the RCMP, I know some people that have experienced timber theft, they call up the RCMP. It's like, hey, if somebody came and stole my car, you'd be all over this if I could tell you who it was and how it happened and had some evidence of it. But they say with timber theft, it's really hard to prove the intentional act of the theft. And of course, with a criminal offense, you have to prove that they did it, but you have to also prove that they intended to do it. And if you don't have a very clear boundary, then the person that did the quote-unquote theft can pretty easily say that it was a mistake and therefore it's not a criminal offense. However, it's still trespass, and so if you are in that situation, you still can have some legal recourse to try to get compensation, to try to get some sort of restitution for that trespass onto your land. Of course, it costs money because you'll have to hire a surveyor to prove that the trespass was onto your land, and then you have to somehow prove what the value of that wood was that was cut. There was, I don't know, there's an example here on the slide. One of the more brazen timber thefts that I've heard of was actually up here in Cape Breton. And the contractor came on to a property. The contractor had actually asked to cut this land, and the owner was kind of interested and then decided not to. The owner is from Ontario, went back for the winter to Ontario, came back the next summer and found about half of her 200 acres had been cut, and eventually figured out that the wood had been sold to the mill, Port Hawkesbury, and Port Hawkesbury does require a signature from the landowner. So what the contractor did was forge the signature of the landowner. So that does tend to get people in hot water. Forging someone else's signature is probably viewed as even a worse crime than stealing the trees. Anyway, if you're contemplating, stealing wood, don't try to forge someone's signature. You'll probably get caught. Anyway, so that was an interesting one, and I think it's still working its way through the court process. I haven't heard the latest on that one, but that fellow was charged with both theft and sued for trespass. So we're facing both a civil lawsuit plus the criminal prosecution. Like I say, for trespass, you have to. Its best case scenario is if you can prove that they willfully neglected to look to see where the boundary line was, or they willfully crossed the boundary line. If it was an honest mistake, then you can still be successful because it doesn't matter if it was honest or dishonest. But the amount of compensation you would get would probably be less than if you can prove that it was a willful act of trespass. Ideally, I always say that the best course is to avoid lawyers at all costs. However, the one good thing about a lawyer is that sometimes a lawyer can help avoid going to court. And more than avoiding lawyers, you really want to avoid going to court whenever possible. Sometimes it's the only option, sometimes it's the best option. But I've got one property dispute now, one boundary line dispute where I think we're 4 years into it now, almost 3.5 years, almost 4 years into it, and we still don't have we're still looking at a trial next year, and the legal costs are probably up to, on both sides, around $200,000, and we're talking about a tiny little sliver of land. It's like, oh gosh, it's just terrible. It's absolutely terrible, and you still don't know who's going to win ultimately in the court case. So yeah, try to avoid going to court by all means. Like I say though, a lawyer can help get a settlement that works for both parties. And they always say the thing with the settlement is that ultimately a good settlement is where nobody's happy, where each side actually gives up a little bit. a lawyer can help navigate that and show the relative strengths of your legal case. So I've been involved in a couple of settlements that involved some sort of timber issue, theft issue, or a mistake, a tree cutting mistake. One also up here in Cape Breton, landowner discovered that there had been an extraction road cut across her property. And so she negotiated negotiated with the logging company that she would receive a number of cords of firewood that we estimated was cut from her land. That fire would be delivered to her property. They would do a land swap, so that the logging company actually got land that was advantageous for them, and then she got land that was advantageous for her, just the way the properties were configured. And there was some money exchanged hands too. And that was great. That was a really nice, ideal outcome, because actually both sides kind of benefited a little bit from that, and they avoided going to court. So that's a kind of like you wish that would happen every time. That kind of an example. Another example, there was a single sugar maple tree was cut off of the person's land, and this woman, she phoned me up and she said, "Somebody cut down my maple tree." I said, "Gosh, that's terrible. Who did it? Who did it?" She said, "I don't know." And I said, "Okay, well, this is going to be tricky." But eventually I said, we figured out that it was probably somebody working, doing some power line work. And so I called up the biggest arborist company in the Maritimes, and I said, "You cut down a tree on my client's property." And they said, no, we didn't. But I think we know who did. So I said, "Okay." So I called up that arborist company, and they said, "Yes, we did. Yeah, sorry very much." And I said, "Well, here's an arborist report on how much that tree is worth." Turns out that one tree was valued at around $11,000. Who knew? And the arborist, the company responsible for cutting it down, said, "Thank you, and here's a check." And didn't try to negotiate. Definitely didn't want to go to court. And another successful outcome for that landowner. Obviously boundaries, like mark your boundaries. It's always easier said than done. I mean, my own woodlot, I don't have all of my boundaries perfectly marked, but embarrassed to say, but as much as you can, make your boundaries obvious. Like, make it really obvious that if somebody were to cross that line, it's pretty hard to say that they just missed the boundary line. Walk your lines often, walk your property often, so you have a regular idea of what's going on in your land, so that you can catch this as soon as, or very soon after it happens. Get to know your neighbors, chat with your neighbors. Say, "Hey, do you want to go out and walk the boundary lines together?" Get to know who they are and what's going on in their property. Not all neighbors can be neighborly, but if you can, it can help solve problems before they happen, which is the best outcome. And of course, act quickly. If you ever do notice theft on your property, or whether it's real theft or just a mistake, always best to act quickly, to document everything, take notes, have written, just write it out or type it out, take pictures, take video, have as much of a paper trail as possible in case you ever need it, if it ever comes to actually trying to prove these things. It's always good to have that paper trail. Common law trespass. If somebody walks on your land, technically it is a trespass, but at least here in the Maritimes, we have a pretty we don't get too worked up about it. As long as somebody doesn't actually damage someone else's property, generally speaking, we don't really worry too much about it. And certainly that's the way the courts view it as well. I've seen a few trespass cases where there was no damage done to the property, and the judge says, "Well, okay, how about $10 as damages." So obviously it costs a lot more than $10 to get yourself into court. So the judge was kind of saying, come on, really, the person just walked across your land. The Protection of Property Act is something a little bit different, because that's legislation, and that applies more to people's immediate property around their houses, or to agricultural land, or to active, an orchard or an active forestry operation, something like that. But if somebody does come onto your land, in those types of land uses, then you can call the police, and you can give notice to that person to leave, and then you can call the police, and the police can actually come and escort the people off, or tell them not to be coming onto that portion of the land. The Protection of Property Act doesn't apply to recreational activities on just pure kind of woodland property. So you can't call the police for somebody just walking on the back 40. An act that I've used, not actually actively used, fortunately, but I have walked past a few no trespassing signs. If I have a fishing rod and a fishing license, in fishing season, if you are lawfully engaged in fishing, you can cross anyone's property. Not like similar to the Protection of Property Act, you can't go across somebody's lawn, you can't go through their front yard, you can't go through agricultural areas, but if you're just walking through somebody's woods, then you actually in Nova Scotia have the right to do so by legislation, thanks to the Anglers Act. One more slide here, accessing land. Oh, yeah, the question? No, that's different. No, we just protect fishers. Yeah, if you're trout fishing, you're good. If you're hunting, no, it doesn't work for hunting.
What if that person that used the Anglers Act to access the river got injured? Could you be liable?
Liability, luckily here in Nova Scotia, liability is pretty limited for landowners. It really only comes into play if you actually create hazards on your land. Like if you're creating pitfall traps, or if you're setting up some sort of snares, if you create hazards and fail to let people know about those hazards, then you could be held potentially held liable or found liable. But if you're just letting people walk in your land, and they hurt themselves, they assume that risk. Yeah, under the Occupiers Liability Act. Yeah. Yeah.
Last year, the province banned everyone walking, so that overrides everything. You want to fish or anything, you can't go anything.
That's right. Yeah.
What was it?
There is a court case about that.
They never settled it.
No, I think they did today. This is yesterday.
Did it just come out?
The governor was in care. They're not allowed to.
Oh, interesting.
Yeah, it just came out.
I haven't seen the decision yet. Yeah, I'm still. I'm ready. Yeah. Well, with the ban, there was some people challenged the woods ban last summer. That was in effect last summer for the wildfires or fire risk, and some people challenged or one. And apparently the decision just came out. So I hadn't seen that decision yet, but
Just yesterday.
apparently it just came out yesterday. So.
The veteran one.
Yeah, according to this person, the person that challenging it won. It may be appealed because this is just the first level of court. It may be appealed, but probably will be appealed. But interesting. Yeah, I look forward to reading that decision. Yeah. If you have a landlocked property, there is legislation in Nova Scotia that provides that you can access that land. You can basically force your neighboring landowner to allow you to have access to it if you're using it for farming or for forestry or for mineral extraction. You can basically force the landowner to give you an access across that land. You do have to pay for basically everything. You have to pay for that person's time in court. You have to pay for the some sort of compensation for the right of way, but it is a possibility if you do have a property that you want to try to access that you can't get to it any other way. You can go through that act, through that legislation, and get access. I kind of rushed through that, but does anyone have any? There's so many other things that we could talk about. We could talk about conservation easements. We could talk about all kinds of fun stuff. But yeah.